All right, everybody, welcome. Thank you for joining us. My name is Eric Tonsul. I'm one of the shareholders in the POA section of our firm. Today, I'm presenting the most recent legislative update for the 88th session. So we're going to be talking about anything and everything legislative session. I will say this webinar is a little bit different than what I normally do. Normally, I do a lot of talking and expounding on what the content of the webinar, where this is a little bit different because we're talking about proposed bills that may or may not become law. And so the information on these slides that you're going to see is really, there's a lot of information, and I think it'd be very helpful for you guys to have the slide deck. And so what we're going to do is I'm going to ask Kyle to put the PDF of the slide deck into the chat of this webinar, so you guys can download it from there, and that way you'll have the most recent information that we have. And so as a reminder, we're still in the session. We'll talk about the dates and all that kind of good stuff, important dates, applicable dates. And so, sorry, I just read a comment. But again, we're not at the end of the session quite yet. So these bills still have a possibility of being changed. So keep that in mind. What we're going to talk about today is the information as it is today. The content of a bill could actually change between now and the end of the session. So be aware of that. So I bring that up because what we'll do at the end of the webinar, we'll have a Q&A. But again, asking specific questions about a bill, it's kind of because the language may change between now and the end of the session. So keep that in mind. Now, that being said, we will, once the session ends, which I believe is May 30th, which is next Monday, we will be putting out our newsletter the first week of June. And in that newsletter, it will have all of the information as far as what bills passed, which ones did, and that kind of thing. And then also on June the 8th, my fellow shareholder Clint Brown will be presenting a webinar just like this, giving you guys an update on everything that did pass and the language of those bills that passed. So that's going to be a very important webinar. Again, that's June the 8th. And again, the newsletter is the first week of June. So you guys keep that in mind. So with that, we'll go to the next slide, please, Kyle. So again, the agenda is very short. We're going to talk about the key dates here shortly, and then we're going to talk about the bills themselves. Next slide, please, Kyle. So these are the key dates. I'm only going to talk about the ones in the future. So May 29th, as I said, is Monday. That's sign die. That's when the session concludes. And then June 18th, all passed bills that are not signed by the governor or vetoed become law. So those are the two key dates going forward. Next slide. So these are the key dates in May for the House of Representatives. Again, today, May 23rd is the last day for the House to consider the second reading of Senate bills and Senate joint resolutions on the daily or supplemental calendar. May 24th, tomorrow, the last day for the House to consider local and consent Senate bills on the second and third reading, and all third reading Senate bills and Senate joint resolutions on the supplemental calendar. May 26th is an important date, last day for the House to act on Senate amendments to concur request to conference committee. Again, that's the last day that the House can potentially change a proposed bill. May 28th is the last day for the House to adopt conference committee reports or discharge House conferees and concur in Senate amendments. And May 29th, again, signed that last day of the session. Next slide. Tomorrow is the last day for the Senate to consider all bills and joint resolutions on the second or third reading. May 28th, last day for the Senate to concur in House amendments or adopt conference committee reports. So May 28th is the last day that the Senate can make any changes, potential changes to proposed bills. And then May 29th, last day of the session. Next slide, please, Kyle. And if you guys don't see in the chat, Kyle has uploaded a link for the slide deck, today's slide deck. All right, so let's get into it. SB 1588 corrections. So in the 2021 legislative session, there was SB 1588 was a big omnibus bill, which put a lot of new law out there. It was kind of a mess. And so SB 1668 is trying to correct some of the mess that was created by 1588. And so it will apply to HOAs and condominiums. Next slide, please, Kyle. So for condos, it would add 821142 to the property code. It'll require condos of at least 60 units, or if they have a management company, to have documents on a publicly accessible website. This mirrors the statute that applies to Chapter 209 associations. 82116 would require management certificates to be filed with TREC, and 82157 would cap resale certificates at 375. So again, all that does apply to 209 associations currently. So this is going to make it applicable to condos as well. Next slide. Security fencing, how that wonderful law that went into effect in 2021 that had everybody scratching their heads as to what the heck is this. So this this would address 202.023C, and it would be amended to allow the association to prohibit the placement of fencing that obstructs a sidewalk, drainage area, or easement or license areas, require a driveway gate to be set back a sufficient distance from the street to prevent a vehicle entering the gate from impeding a passing vehicle or pedestrian, and unless otherwise provided in dedicatory instrument, prohibit the installation of fencing in front of the frontmost building line of a dwelling, or impose other regulations related to the building or installation of security measures that the property owners association determines are necessary to prevent or minimize a hazard or risk to health or safety. Next slide, Kyle. Another correction to 209.005C, redesignated as 209.00506, and amended to require a person wishing to serve on the ACC to timely notify the association in accordance with 209.00507. 209.00507 does not currently exist. Again, there's a bill to create 209.00507. And so what that is, it's very similar to the solicitation notice for candidates to the board of directors. It would now create very similar, if not identical, solicitation notice requirements for ACC members. It would also allow the association to appoint someone not currently eligible to serve on the ACC if all those eligible under the new statute have been given positions and vacant positions still remain. And 209.0507 adds notice requirements for the election or appointment of ACC members, which is what I just mentioned earlier as far as a solicitation notice, similar to the board of directors. Next slide, please, Kyle. Senate Bill 1363, relating to the enforcement of a POA of a restrictive covenant that prevents a property owner from building or installing certain security measures. This would amend 202.0232C to allow a POA to adopt or enforce a restriction prohibiting perimeter fencing in the front yard if the restriction has been approved by 75% of the owners. This only applies to 209 associations, but again, this is kind of a compromise of allowing front yard fencing, but if this bill passes in its current form, if 75% of the owners vote against it, front yard fencing, then you can enforce that restriction prohibiting front yard fencing. Next slide, Kyle. HB 3776, relating to the eligibility of solicitation of persons to serve on the ACC of a POA. So it mirrors the language in 1668 and HB 3503. This would apply to HOAs only. Next slide. Okay, 1367, relating to the violation of certain laws and provisions of governing instruments by and the recall by property owners of a POA board member. And so this would apply again only to 209 association. This would give, I believe, go to the next slide real quick. I think it's on the next slide. Yeah, here it is. So what it would do is it allowed 20% of the voting owners of an association to petition for a recall election. In other words, a removal of a board member. If 20% of the owners submit the petition or sign a petition calling for a meeting to recall a board member, the election must be held not later than 90 days after the association receives the petition, and it's a majority vote in order to have a board member removed. And then section 209.018, an owner can bring an action in JP court if a board member violates 209 or the association's dedicatory instruments. If the court finds there is a violation by a board member, the remedies would include immediate removal of the board member from the board, a financial penalty to the association for damages incurred by the owner resulting from the violation, or allowing the owner to deduct the amounts awarded from future regular or special assessments. So that's a pretty big one there. Right now it's usually I mean, you do have most governing documents allow an owner, and the business organization code allows a certain percentage of owners to call a special meeting. And so, but this puts a definitive point on there where it would be 20%. Sign the petition, then there's deadlines now and time periods and what will happen, and there's also a penalty if a board member violates 209 or the governing document. So if that one passes, that's a pretty big one. Next slide. Okay, HB 1786, relating to the notice to property owners of the adoption or amendment of certain covenants. This would apply to condominiums and 209 associations. POAs would not be able to enforce adopted or amended restrictions prior to the 60th day after notice is given to property or unit owners and their strict notice requirements. And so I won't go into all the notice requirements, but some of the big ones are: you have to post the notice in a newspaper of regular circulation in the county where the association is located. You have to mail the proposed information or the proposed amendment via certified mail to all the owners in the community. So there's a pretty large or significant financial impact on the association for trying to amend the governing documents, the deed restrictions. So that's kind of a mess. And then 209.042B would amend to mention notice requirements under 202.045, which is what I just told you about. So, if that one passes, that's going to be pretty substantial, because the way it is right now, if you amend your declaration, whatever the amendment process is per your governing documents, you follow that, assuming you get the requisite approval, then you have the amendment signed and notarized, and then you record it with the county, and the amendment then becomes enforceable once it's recorded with the county. Well, now you have to wait 60 days, and then you have these strict notice requirements I was telling you about. Next slide, please. HB 1799, relating to the authority of POAs to regulate the street parking of certain vehicles. A POA could not restrict the street parking of government vehicles, vehicles used in course of a resident's employment, vehicles required by a resident's employer to be parked in the immediate vicinity of a dwelling. That would apply to HOAs and condos. And I see some chat questions in the chat. Again, keep in mind, guys, these are not passed yet. There's going to be, the last day is on Monday. We're going to provide the newsletter update with the final bills in their final form, and we're going to do we're going to have the webinar on June the 8th. So keep that in mind. I'll be more than happy to answer the questions at the end that I can, but keep in mind that all this is only good as of today. Things will most likely change by the end of the session. Next slide, please, Kyle. HB 998, relating to provision of POA insurance by the Fair Plan Association in certain areas. This will allow this is going to amend the insurance code if it passes. This will allow the Texas Department of Insurance to include in its fair access to insurance requirements plan the delivery of POA insurance in underserved areas. The commissioner will make a determination if the POA insurance is not reasonably available in the voluntary market to a substantial number of insurable risks. And this would apply to condos and HOAs. Next slide, please, Kyle. HB 614, relating to fines. This would require the adoption of a deed restriction enforcement and fine policy, which would establish fine types, a schedule of fines, and filing and posting requirements. This would apply to HOAs only. This does not apply to condominiums. This would, most of our associations that I work with have a deed restriction enforcement and fine policy already, so that wouldn't impact that aspect of it. But the filing and posting requirements would impact associations, even if they already have a fine policy. Next slide, please, Kyle. HB 330 relates to the regulation of residential wind power facilities. Residents would be able to install a wind power facility of appropriate residential scale. That's verbatim from the bill. The problem is there's no definition of what appropriate residential scale means. So if this one passes, hopefully they add some clarification as to what the heck appropriate residential scale means. This applies to HOAs and condos, although declarant could prohibit during the development period. Next slide, please, Kyle. SB 468, relating to authority of a POA to regulate the assembly, association, and speech of property owners of residents. This would add section 202.013 to the property code. This would apply to both HOAs and condos. Next slide, Kyle. So what it would say is a POA cannot restrict a property owner or resident from peacefully assembling or meeting with POA residents, members, or their invitees or guests in common areas, inviting guest speakers, including public officials and political candidates, without prior POA approval to meet with POA residents, members, or their invitees. Exceptions are if it threatens public health or safety, violates the law, or contains offensive language or graphics. This particular bill is problematic because we're potentially going to have a large number of folks on association-owned property, and they don't have to get prior POA approval, at least the way the bill is drafted right now. What happens if something happens to, or an injury occurs on POA property, on common area? That could potentially subject the association to liability, but we have no way of, they don't have to get prior POA approval. So that's problematic. And also, I'm not really sure if this extends to the clubhouse. Like if your association has a clubhouse, which is on common area, well, can somebody just, hey, we're going to meet in your clubhouse and without prior POA approval? So there's all kinds of issues with this particular bill in particular. So again, if this one passes, hopefully there's more clarification as to, it puts a finer point on it, because right now there's a lot of open-ended issues that could result in administrative hassle, liability, et cetera, to an association. Next slide, please, Kyle. HB 3775 relates to POA's ability to regulate the assembly, association, and speech of property owners or residents related to government officials or candidates for political office. This would add section 202.013 to the property code. It focuses on political candidates qualified in an appropriate election. The association can enforce gathering to abide by the same rules as other gatherings held in common areas, such as fees, deposits, max occupancy, available hours, reservations, etc. So again, this one does have a finer point on it as opposed to the prior bill. So we'll see which, if any, pass. And so this would also apply to HOAs and condos. Next slide. HB 886, this relates to requirements to file a POA assessment lien. This is kind of a nightmare bill. This would require 3 additional notice requirements and a 180-day waiting period prior to filing a lien. So it would add approximately 9 months to the collection process. This is a nightmare bill. Hopefully this one doesn't pass. It's a mess. But this would apply only to HOAs, not to condominiums. So we'll see how this one plays out. If this one does pass, this is going to be a huge stall factor. In those 3 additional notice requirements, I believe there's a certified mail requirement as well. And so again, increasing costs to the association, which is ultimately going to be passed on to the homeowner. So you're increasing costs, increasing delay in time. It's kind of a nightmare. So we'll see what happens there. Next slide, Kyle. HB 1307 relates to municipal release of ETJs and disannexation involving certain areas. So the majority of voters in a POA that lies in a municipality's ETJ could petition to be released from the jurisdiction. This applies to only 209 associations only. Next slide, Kyle. HB 1252 relating to the audit of financial records of certain POAs. So single-family POAs, again, 209 associations, would be required to conduct an annual audit of financials. This is already a requirement for condos for 82114. It's probably not a bad idea for associations to have that requirement. Again, it is, again, a cost to the association, but make sure that somebody's minding the store, so to speak, is from a financial standpoint, or the financial health of the association. Next slide, Kyle. HB 1193, regulating or relating to prohibiting housing discrimination by a POA against a residential tenant based on the tenant's method of payment. So a POA would not be able to restrict Section 8 housing vouchers. This would apply to HOAs and condominiums. Next slide, Kyle. HB 378, relating to authority of certain entities and individuals to prevent individuals from accessing private property for the purpose of registering voters or communicating political messages. So this would most likely affect the elections code. So the POA could not restrict individuals from approaching residential unit for purposes of voter registration or disseminating support or opposition to political candidates, parties, or measures. So this would apply to HOAs and condominiums. So if somebody is approaching a residential unit for these governmental elections, you cannot restrict those owners from approaching a residential unit if it passes. Next slide. HB 328 and 329 relating to the regulation of a POA of the installation of solar roof tiles. So this is going to clarify that solar energy device has the same meaning assigned by section 171-107 of the tax code. Next slide, Kyle. HB 3423 and SB 1767 relating to the organization of meetings of and voting by condominium unit owners associations and POAs. Chapter 82 would be amended to allow for virtual meetings and electronic voting regardless of what the bylaws state. We already have that in 209 in the BizOrg code for 209 associations, so this would extend the same ability or capabilities to condos. Section 209.0592 would be added to amend, add electronic ballot as a recognized voting method. So those are very good. Hopefully that one passes. Next slide. HB 3064 relating to the right of a POA members to speak at an association or board meeting. This would add section 209.00511 requiring a homeowner forum for every association meeting. The POA could restrict the time and manner in which the member is able to speak. This is only for 209 associations, only not condominiums. This could be not good. It depends on your association. Most associations at a board meeting already typically have a homeowner forum and restrict the time that they speak, but this would make the homeowner forum a requirement and not optional. Right now it is optional. It's up to the board whether or not they want to have a homeowner forum. This would make it mandatory, but again, you'd be able to restrict the time and manner in which the member is able to speak. Next slide. HB 276, HB 92, SB 326, HB 1191. The chicken bills and maybe rabbits. So these bills are all kind of generally the same. They address raising 6 or fewer fowl or rabbits, growing fruits and vegetables, installing solar, rain barrels, and rain harvesting systems and generators in cottage food production, HOAs only. So admittedly, the chicken bill has been on the docket for the last 3, 4, 5, 6, however many legislative sessions. It's always failed. We thought that this might be the year of the chicken, but believe it or not, the bills have kind of stalled. Again, we still got about a week left in the session. Not to say they can't ramp up and get passed, but right now they've kind of stalled, I believe, in the Senate. So we will see what comes of that. So HB 92, public comments were largely positive in support of the bill as written. The bill could be problematic for POAs due to lack of details on the restrictions POAs can pass, health and safety issues if every home has their max amount of a combination of 8 rabbits and fowl, and property value issues with increased wildlife activity due to the placement of vegetables. So those are some of the pitfalls that we may see if that HB 92 passes. Next slide. HB 276, similar requirements to HB 92, but only focuses on vegetables, fowl, and rabbits, would allow for vegetables to be placed in the front yard. Not sure how you guys feel about that. Probably better for them to be in the backyard, but we'll see. Next slide. SB 829 would amend several sections of Chapter 437 of the Health and Safety Code to allow for cottage food production in an individual's home without a license or permit. So that's, again, there's various different bills relating to the chickens and the fowl and the rabbits and the fruits and vegetables and cottage food. So these are all the ones in their form. Again, no idea whether some or all or none, are going to pass. So time will tell. Next slide. So other bills of interest, here's the bills that are showing movement as of today. HB 1558 relating to the extension or amendment of deed restrictions in certain older subdivisions. HB 1900 relating to the notice of non-renewal of a property and casualty insurance policy. HB 1957 relating to the availability of financial information of nonprofit corporations for public inspection, and HB 2153 relating to the amendment of restrictive covenants applicable to certain subdivisions. So those are other bills of interest. Those are kind of more specific, or I say association specific, depending on your association. So we'll keep an eye on those, and we'll let you know the outcome next week. Other bills showing movement are HB 2127 relating to state preemption of certain municipal and county regulations, HB 3777 relating to the confidentiality of ballots and proxies in a POA election or vote, and SB 1768 relating to the correction and removal of certain obsolete provisions of the property code. Next slide, Kyle. I believe that's it, right? Oh, I'm sorry. Bills not showing movement. HB 2174 relating to the authority of a POA to require a fee for the review or approval of a proposed solar energy device installation, and HB 2267 relating to the sale of unplatted lots in certain subdivisions of land. And I believe that is the last slide. Sure is. All right, let's go to the chat, and I will try to answer as many questions as I can. Let's start at the top. All right. Once again, Kyle, in the chat, if you click on the chat button, Kyle has uploaded the slides. You can download or click the link to obtain them. Okay, HB 1367. Do 20% of the owners need to physically sign a petition? Is electronic voting permissible? That depends on what form of the bill is. How the final language, if the bill passes, what the language in the bill says. Right now, I don't believe it says electronic voting, but again, we'll see how that plays out after it's over. HB 1786, is this pertaining to any amendments to the restrictive covenants? Yes, Jack, I believe it does. 1786, certain restrictive covenants, examples. I don't have any examples right now, but again, this would be maybe a situation where when the bill is finally, assuming it's passed, that they will have information speaking to that issue. 1786, does this apply to developer controlled as well? If I did not mention a carve out for developer controlled, then yes, it would apply to developer controlled as currently drafted. There's a comment. Will a review suffice for an audit? Again, I believe that the bill actually says a licensed, like a CPA or something along those lines. So when you say will a review suffice for an audit, again, it depends on the final version of the bill that's passed. But I do believe it requires a licensed CPA. With HB 886 and the 6-month delay after the third notice, doesn't the 109 expire, and won't a fourth 209 be needed, adding a fourth certified letter and cost, as well as another 30-day delay before the lien can be applied? So again, as you said, it could add 9 months to the collection process. So a 209 letter, a collection 209 letter does not expire. However, if you wait more than a year and additional amounts are added or become delinquent before turning that account over to your attorney, you would have to send a new 209 letter so it reflects all the amounts that are currently due to the association. So I don't think everything, Valerie, that you put in your chat is necessarily applicable from the collection standpoint, but there's no question it would definitely add a significant amount of time. And again, depending upon if it passes, and if so, what version of the bill is finalized, that will be information that we'll have a finer point on at that time. Again, if you can't hopped on late, we're going to put out a newsletter the first week of June. Once the session is over, we're going to say all the bills that passed. And then on June the 8th, Clint Brown is going to present a webinar on all the final bills in their final format. So there'll be a lot. Right now, this is a little bit loosey-goosey. I apologize for it, but just because right now these bills can still be changed. And we obviously don't know which ones have passed, which ones have not. So that's why there's a lot of, I might sound a little wishy-washy, but it's because there's a lot of variables at play here right now. We're not knowing the session. Is a full audit required, or will a review satisfy? Okay, answer that one. HB 1252 does not define what an audit is. In the CPA world, a review is not an audit. Thanks, Rich. HB 3064 is a time limit included in this. I believe, Jack, it's going to just a reasonable time limit. I don't think there's a specific time limit in the current version. You and I will definitely have that discussion at a later date. I already talked about the chickens and vegetables. HB 276 with regard to front yard only. If you look on the slide, Lauren, if you get the slide deck, at the bottom left corner of the slide, it says whether or not it applies to HOAs or condos or both. So just pull the slide deck and look at that. That'll answer your question. Evelyn, HB 2174, would the bill prevent HOAs from charging fees for solar panel review unless there's an express prohibition on that? Evelyn, I think if you have the authority in your governing documents, then you can charge a fee of that nature. What happens to HOAs that do not implement new laws? Well, there's a proposed, as I mentioned, there's a proposed bill that, and actually there's a current law that it's, I believe 209 I want to say 0016, it might be 0017, that says an association can be sued for failing to comply with Chapter 209. That's already in play. An owner can sue an association in JP court. So if an association, intentionally does not follow the new laws that are out that become, if any of these bills become law and an association intentionally does not follow them, that could subject the association to a lawsuit. Okay, where's the link to download? Lori, if you scroll to the top of the chat, probably about the 5th item from Kyle, he put the link in there. Regarding HB on CCR amendments, so if passed, it means that not only does the POA members have to vote on the changes, most may due to the legislative updates, but then we have to notify the members via certified mail. Please clarify. Yes, you'd have to notify the owners via certified mail. Again, as I mentioned, increasing cost and time and everything else. Okay, Rich, thanks for the clarification. HB 1252 does not contain language that they ought be performed by CPA. My apologies. So again, I would encourage you to, and in our newsletters that we've already put out, we have much more in-depth discussion about these bills and what they say. So if you go to our website, rmwbh.com, and go to the education tab and look at our blog, again, we put out a legislative update with each newsletter. You can see exactly what the bills say. I don't have them all memorized. My apologies. But again, if you go to our website, and then again, the newsletter is coming out first week of June, you'll have the finalized format. Let's comment. All right. Sorry, there's a lot of just comments on here. Under 209, what remedies does a JP have under current law to encourage an HOA to comply other than monetary awards? It's it's really just monetary at this point. And if there's any awards awarded to an owner, they can have the cost either the judgment paid to them, or they can offset current or special assessments in the future. When is the last day for a House bill to pass the House? That is let me see here. May 26th is the last day for a bill to pass the House. All right, Kyle, thank you for answering Lauren's question. All right, so those are all the questions. Again, like I said, a lot of uncertainty right now. Next Monday is the day the legislative session concludes. That's when we'll have a much more definitive, well, I say that definitive understanding of the new laws, as we saw with last legislative session, especially 1588. There's more questions than answers. Hopefully we don't run into the same situation this year. Time will tell. I know I've said this over and over again, but again, our newsletter beginning of June will come out with all the finalized bills that were approved. And then Clint on June the 8th will present a webinar on all the finalized bills that were approved. So be sure that you check out our newsletter and our webinar. And again, there'll be a lot less. It depends maybe that's going on in this webinar. But again, that's just par for the course with a legislative session. Things can happen at the last minute. And so that's hence all the disclaimers. Again, you're welcome. So people said thank you for this webinar. I hope it was helpful. Thank you for joining us, and we will see you on June the 8th, I believe, with the next webinar with Clint. And I hope you guys have a great rest of your day. We'll see you guys next time. Take care. Bye-bye.